House Standing Committee on Local Government. Madam Secretary, please call the roll.
Representative Bentley. Here. Representative Bowling.
Here.
Representative Bray. Here. Representative Brown. Representative Chester Burton. Representative Dixon. Here. Representative Doan. Present. Representative Frazier Gordon.
Here.
Representative Freeland.
Here.
Representative Imes. Representative Justice.
Here.
Representative Lockett.
Here.
Representative Meredith. Here. Representative Proctor.
Here.
Representative Raymer.
Here.
Representative Reed. Representative Stalker.
Present.
Representative Stevenson. Representative Thomas.
Present.
Representative Bridges.
We have a quorum and are duly constituted to take action. We have one bill on the agenda today, Senate Bill 141. Senator Bledsoe, Chairman Bridges, if you want to make your way to the table. Introduce yourself and you are free to proceed.
Thank you. Amanda Mays Bledsoe, District 12.
Representative Randy Bridges, District 3.
Okay, thank you, Chairman and committee members. I'm here to speak on a portion of Senate Bill 141. And the portion I'm going to speak to is how code enforcement liens have been streamlined to make collections easier and help cities eliminate blight and vacant properties to make them more affordable and more viable business use. A few changes are the following. First, if cities prepare their property tax bills and do property tax collections themselves, they can include the amount of any outstanding code enforcement lien on this bill. It must be treated and listed as a separate item on the bill and may not be considered part of the underlying ad valorem tax liability. And second, if the code enforcement lien is not paid or is paid after the due date, it can only be enforced through the traditional code enforcement lien process. Secondly, the legislation permits the city to use the provisions of the Mass Foreclosure Act to enforce uncollected code enforcement liens the same manner that cities use the provisions to enforce unpaid property taxes. This allows properties of defunct nonprofits that have been blighted, other vacant and abandoned properties without outstanding tax liabilities, or properties that are not being maintained with multiple known errors to be included in these corporate hearings where due process will permit the transfer of clean titles to a master commissioner's sale.
Motion on the sub.
Have a motion and a second on the sub. All those in favor, please say aye.
Aye.
All those opposed, the sub is adopted.
Okay, I appreciate you, Senator Bledsoe.
Thank you so much.
She's been kind enough to allow us to add a committee sub to this. This committee sub starts in Section 3, and this is what has become known over the last few days as an annexation bill. There's been a lot of work around the clock for the last several days on this, and I believe we have come to concessions. I'm going to go through the basic parts of the bill, and then I'm going to invite two guests up to introduce themselves and let them speak on the bill. We'll have J.D. Cheney from KLC and Jim Henderson from KCO to come up and speak to that. And you gentlemen can come on up. We start in Section 3, and this is a city that is initiated annexation under KRS Chapter 81A on or after March 1st of 2023, but has not completed the annexation prior to the effective date of this act, shall not complete the annexation unless it meets the requirements of subsection 3 of this section, in addition to any other statutory requirements for the annexation. On or after the effective date of this act and prior to July 1st of 2024, a city shall not initiate annexation procedures under KRS Chapter 81A except as set out in subsection 3 of this section and in addition to any other statutory requirements. Annexation within the time limits prescribed in subsections 1 and 2 of this section may proceed or be initiated if the city can demonstrate that an opportunity for substantial economic development has been impeded if a parcel of land is not annexed. Such a demonstration would include the necessity of the extension of city services to this parcel for the location of the business or other development that provides evidence that it will not locate in that parcel absent services specifically available from the city. Annexing the parcel of land would directly facilitate the delivery of new or substantially improved services that cannot be provided by the city or any subunit of the city. Absent annexation or the lack of annexation will result in a substantial loss of services. A contract let prior to the effective date of this act will be voided by the moratorium in the case of an annexation underway as described in subsection 1 of this section. The property owner made a request for the annexation of his or her property. The property is contiguous to the existing city boundary, and the city has provided written notice to the fiscal court wherein the property is located at least 45 days prior to enacting a final ordinance. E, the city has received concurrence for the annexation from the fiscal court. F, the provisions of this section would void, alter, or otherwise impede the continuation of any provision of an agreement executed by a county and one or more cities under provisions of KRS 65.210 to 65.300 involving an occupational license fee or insurance premium tax. 4, in addition to any persons withstanding otherwise provided by statute or under common law, the county government containing the city asserting that an annexation completed within the time frame prescribed in subsections 1 and 2 of this section was completed without meeting the demonstrated necessities or exceptions as set out in subsection 3 of this section, shall have a standing to challenge the annexation in the circuit court of jurisdiction, provided that the action is initiated no later than 45 days following the date of the publication of the ordinance finally annexing the territory into the city. Upon completion of the annexation pursuant to this section, written notification shall be sent to the county judge executive of the county in which the annexation occurred. 5, except as provided in subsection 6 of this section, the provisions of this section shall not prohibit a city from completing a proposed annexation that was initiated by the first reading of this ordinance to annex property pursuant to KRS 81A.412, or the first reading of an ordinance declaring the intent to annex property pursuant to KRS 81A.420 prior to March 1st, 2023. Cities meeting the conditions set out in this subsection shall not be required to meet the requirements set out in subsection 3 of this section. When annexation is required in order to maintain ongoing services provided by a city to a school, no city prior to July 1st, 2024 may initiate or complete an annexation of an area that includes any property owned by that school district unless requested by the school district and concurred with the fiscal court of the county. The provisions of this section shall not apply in counties that have adopted urban county form of government pursuant to KRS Chapter 67A or the consolidated local form of government pursuant to KRS Chapter 67A. And that particularly addresses Jefferson County and Fayette County. Am I correct, gentlemen? Okay. There's been a lot of questions on that. The Legislative Research Commission is hereby directed to establish a task force on local government annexation. Task force on local government annexation shall investigate and make recommendations regarding the present statutory methods for the city annexation, the beneficial and deleterious effects of city annexation on issues such as taxation, economic development, provision and sustainability of water, gas, electric, sewer, and other utility services, police protection, fire protection, and emergency services from the perspective of local governments and their residents, and any recommended change to statutory law arising from the task force deliberation. The task force on local government annexation shall consist of 4 members of the Senate appointed by the President of the Senate, one of whom shall be a member of the minority party, 4 members of the House of Representatives appointed by the Speaker of the House, one of whom shall be a member of the minority party. Final membership of the task force is subject to the consideration and approval of the Legislative Research Commission. Section 7, the task force on local government annexation shall meet at least monthly and shall submit any findings and recommendations to the Legislative Research Commission for referral to the appropriate committee or committees by November 1st, 2023. Section 8, provisions of sections 4 through 7 of this act to the contrary notwithstanding, the Legislative Research Commission shall have the authority to alternatively assign the issues identified herein to an interim joint committee or subcommittee thereof and to designate a study completion date. Section 9, sections 4 to 8 of this act shall have the same legal status as a Senate concurrent resolution. In Section 10, where it is important to ensure that cities may begin to put in place measures to collect outstanding liens, and whereas it is important to ensure that any deleterious effects of annexation are ceased at the earliest opportunity, an emergency is declared to exist, and this act takes effect upon its passage and approval by the governor or upon its otherwise becoming law. I'm going to speak to just a few things that I have been asked from members, and I'm going to direct these, if you don't mind, Mr. Chair, to the gentleman on either side of me to make sure we're all in agreement, we're all on the same page. This is a moratorium for 1 year on annexation with exceptions. The first two that I've already noted are for counties, and basically Jefferson County and Fayette County. They have different forms of government where this is not necessarily applicable. There are exceptions where there are processes in place that have substantial economic development contracts in place already. There are exceptions where the city and county, the local governments can concur and agree. And there are exceptions for if there is a substantial economic development that comes up during this process. We don't want to impede that economic development. Am I correct on that, gentlemen?
That's a good list.
Okay. And I can assure all those out there, I've talked to, I think I could literally say hundreds of judges, county commissioners, mayors, city commissioners, county magistrates, and all the way down the line. And the intent of the General Assembly, I believe, and my purpose in this is economic development and what we can do to encourage companies to come to the Commonwealth. And when there are disagreements or anything between city and county governments or any governments, it's hard to get a company that's maybe wanting to spend $200, $300, $400 million, possibly $1 billion, and come in and it becomes an obstacle. So the priority is to make sure that we can set the framework, put this group together to look at how it's currently done, see if that's sufficient, or see if there are changes to be made. Am I?
Motion on the bill is amended by the sub.
Motion by Representative Thomas, second by Representative Bowling.
Would like for each, Mr. Cheney and Mr. Henderson both to make a statement on behalf of their organization, if you don't mind, Mr. Chair.
Yep.
J.D. Cheney, I'm the CEO, Executive Director of the Kentucky League of Cities. I know you're unaccustomed to me being brief, but I will be on this occasion. We would like to thank, on behalf of my members, the opportunity provided by the Speaker and Senate President Stivers to have a discussion about this matter. We are anticipating a productive discussion over the interim that this bill provides through the task force. We look forward to having that discussion about, as Representative Bridges said, about economic development and growth in our communities, the creation of jobs, the creation of quality residents that occur in our cities. And we are looking forward to collaborating with our partners in local government in that discussion in a good faith way. As a result of this change, just to be very clear, as a result of this change, the document that you're about to approve, Kentucky League of Cities is no longer opposed to this legislation. Thank you.
I'll just, excuse me, Jim Henderson. I work for KACO. I would echo the thanks for the work that's been going on for the last few days in particular. Both JD and I have spent a collective number of hours together, maybe 10 or so in the last 72 between being asked to meet and talk about this issue after the topic was broached. I know this is a hard topic. I get that, okay? And I've heard from some of you about the process. I don't get to pick the process. So we've tried to work within the framework of the process of the last few days, and I appreciate your all's comments about that. I want to thank you for creating the conversation over the interim to address some of these decades-old laws that are hodgepodge and piecemealed in a way that has been very detrimental for counties. And all we've asked for when we testified last fall before this committee and the joint committee with the Senate was to have a chance to have a conversation, ongoing conversation. And so I appreciate the opportunity to have that in the interim. We just asked for the opportunity to have the playing field be fair for counties, and that's all we've asked for. So we look forward to the task force with your leadership. Here, we're committed to reaching an agreement with our city partners on long-term policy improvements and deliver meaningful recommendations on our behalf, hopefully to you all at the next session. So on behalf of CAECO and its 120 counties, 1,500 plus members, we appreciate opening the door to the dialogue. Thank you.
We do have a motion and a second. I believe there are some questions. Start off with Representative Lockett.
Thank you, Mr. Chairman. I just have a quick question. Section 3, subsection 3A, where it says an opportunity for substantial economic development will be impeded, and it continues on. Could you define for me what substantial economic development is?
Well, JD and I had a lot of conversation about that in one of our meetings. My thought was that it's somewhat intentionally vague to give the broadest interpretation of that from our perspective. I'm not sure that would be exactly the same opinion, JD. I'll certainly let you speak to that.
Ultimately, Representative Lockett, it's not defined in the bill, but it would be defined probably by a court, given the action provisions here that would allow a challenge for any annexation that proceeds under these provisions. That would be debated in court if there was a challenge under this temporary legislation about whether it's substantial. I view it as, personally, from my legal perspective, is that could vary from jurisdiction to jurisdiction. A Quick Mart in Fleming Neon might be substantial, whereas a Quick Mart in Bardstown may not be. So I think that would be relative to what the total budget, what the total economy is, what the size of the city that you're looking at, but ultimately that would have to be determined by the court whether it met the criteria of substantial if it was challenged.
And I want to follow up with that, the key word, if it were challenged. And that is, I agree that is sort of a vague term, but the intentions behind that, as Mr. Cheney has said, it's relevant to the community you're looking at and the size of the community. There's a very small community, a convenience store can be a big challenge, a big deal. In a larger community, it may not. But depending on the community, I feel like that the local governments will look at that, and if it's important to both of them, there's provisions for them to work it out before they have to challenge it in court. And if it's a big enough, if it's substantial, I believe you'll see that happen because we can look at it at earlier factors before this is put in place to where communities have come together and have worked. And in our research, local governments that work together, we have examples where they are flourishing. And that's the intent, to bring us all together, get us on the same page. Let's focus on what we have in common, and that's desires for economic development, rather than looking at our differences and causing divisions. So hopefully this will be an effort to bring that together.
Thank you, Mr. Chairman.
Representative Brown.
Thank you, Mr. Chairman. as has been stated in this hearing, this is rather complicated, and the complications have ensued. When I first talked with the KLC staff about this bill, House Bill 141, Senate Bill 141 rather, did not include anything about annexation. Is that correct?
That is correct.
So the committee sub put in the annexation piece. Is that correct?
That is correct.
Just a statement, Mr. Chair,
Yes, sir.
that I cannot be in favor of the annexation or the code enforcement liens and taking properties. It's a serious problem for me in my district. I understand what has been or what is being attempted to do, but I cannot be in favor of this of the committee sub. Thank you, Mr. Chair.
Any other questions? Seeing none, Madam Secretary, please call the roll.
Okay, go ahead.
Representative Bentley?
Just a quick comment, Mr. Chairman. I'll take 5 of those quick stops in Greene County. But yes,
Representative Bowling?
Yes.
Representative Bray?
Yes.
Representative Brown?
No.
Representative Chester Burton?
Pass.
Representative Dixon? Yes. Representative Doan?
Yes.
Representative Frazier Gordon?
Can I explain my vote, please?
Yes.
I just want to express my sincere appreciation to both of you all for your willingness to work on this and to have this conversation, because it has put a lot of us in a very difficult situation that none of us ever wanted to be in. We respect both of your organizations and what you do for our state and our local communities. So I want to say that off first. And I also want to acknowledge that it is our tax policies and our change in policies that have put us on this trajectory towards an increase in population and economic development. And so this situation is only going to increase as we go forward. And so I think it's very important, and I do appreciate your willingness to do this, and I vote aye.
Representative Freeland?
Yes.
Representative Imes?
Yes.
Representative Justice?
And can I make a quick comment? Just exactly like she said, this was a tough situation to be in. I use the analogy, it's like our parents were divorcing and we were forced to figure out who we wanted to live with. So I think this is a good compromise, and I'm glad that both sides are happy with the situation. I'm a yes.
Representative Lockett?
Yes.
Representative Meredith? Representative Proctor?
Yes.
Representative Raymer?
Yes.
Representative Reed? Representative Stalker?
Yes.
Representative Stevenson?
Yes, with one comment, please. I vote yes because I agree with the divorcing parents that Kentucky can only be as great as its cities and its counties. And if you two are fighting, we don't win. And to Rep. Bridges, thank you for being the, what do they call them, guardian ad litem? And making sure that we can move forward. So thank you.
Representative Thomas?
Aye.
Representative Bridges?
Aye. And I do want to explain my vote, if you don't mind, Mr. Chair.
Go ahead.
There's been a lot of angst go on in the last few days, and this is a tough topic. And I want to express my appreciation to both House and Senate leadership to acknowledge that we got to look at the tough questions and we got to face the tough issues. And in local government, I don't believe there's any tougher issues because we got 2 of the strongest organizations in our state right here. I think the 2 strongest. And I appreciate and I want to extend the appreciation of leadership to both Mr. Cheney and Mr. Henderson, to KCO and KLC. And there would be one person I would be amiss if I didn't acknowledge too, and that's the Vice Chair Bray. He's worked long and hard on this, as is everyone. Our staff members have spent multiple hours, late night, working on draft after redraft after redraft. And there's been, I don't think we could ever name everyone that has been involved in this, but we do appreciate that. And we appreciate our members of this committee and how they've had to deal with short notices, short explanations, a very fluid atmosphere where things were changing by the second, and it is tough, but you've shown the leadership of what you were elected to do here, and I appreciate each and every one of you. Thank you, Mr. Chair.
With a vote of 18 yeses, 1 no, 1 pass, Senate Bill 141 as amended by the committee sub has passed. We do have a title amendment motion by Representative Bowling, second by Representative Bentley. All those in favor say aye. All those opposed, title amendment is adopted. With no other business, we